Hello, this is Jerry Zremski from the Buffalo News Washington Bureau, reporting again from the United States Supreme Court, where the 9 justices just finished their 3rd day of oral arguments in what could be the case of our lifetimes, the case against the Obama health care bill. Now, today's arguments were more important than we originally thought, just because of the tone of yesterday's arguments. Yesterday, the Supreme Court justices, several of them, made it very clear that they're very seriously questioning whether the individual mandate that everyone buy health insurance is really constitutional. And if that requirement is not constitutional, then today's arguments really were very, very important, because today what the Supreme Court really started considering was how much of the health care law can stand. This morning there were arguments as to whether or not that individual mandate was quote-unquote severable from the rest of the bill. And there are really several ways that the Supreme Court could judge this case. It could say that the entire health care bill is unconstitutional because the individual mandate is unconstitutional. It could say that only the parts that directly relate to the individual mandate, those that force insurance companies to cover everyone regardless of pre-existing conditions, and that require insurance companies to base their rates on a broader set of considerations rather than one's individual health, those provisions could indeed go down too if the individual mandate goes down. Or the bill could be struck down in its entirety. Now, the arguments this morning really were very hard to read, except for the fact that it seemed that several justices, including Justice Roberts, the Chief Justice, seemed to have some interest in preserving some of the bill, or at least considering preserving some of the bill. Justice Roberts made the point that several parts of the bill, many parts of the bill actually, have nothing to do with the individual mandate, and in fact are routine extensions of existing federal health programs. Now, we can't really read an awful lot into the tone of that argument that the justices were making. Oftentimes, justices will take the other side from what they often, what they really end up ruling. But at the same time, the questions were very pointed and seemed to indicate that yes, some parts of the law may indeed stand if the law is declared, if the individual mandate is declared unconstitutional. Then this afternoon, we had a separate argument in the parts of the law that deal with Medicaid. Under the health care law that Congress passed 2 years ago, the Medicaid program all across the country would be expanded. Basically, it would no longer be a health care bill just for the poor, it would be for the near poor as well. And to get the states to do that, the federal government is offering them an awful lot of money and saying to the states, okay, you take this money, we'll pay 100% of the cost of these new Medicaid enrollees the first few years, 90% after a few years, and you get all of these new people into the insurance rolls. Now, the argument that 26 states made today, though, was that that was coercive. And the reason those states said it was coercive is because there is the possibility in the law, under the current Medicaid law, that if a state were to refuse to expand its Medicaid program, then the federal government could take away all the state's Medicaid funds and really leave the states on their own for taking care of the health care for the poor. The lawyer for the states said this is obviously coercive, and there was some very serious pushback to that from the liberal justices, such as Justice Breyer and Justice Ginsburg and Justice Kagan, because they made the point that this is really kind of a gift to the states. This is new money to the states, and ask the question, can this really be coercive? In a way, they have history on their side, because the Supreme Court has never ruled a federal state funding program to be coercive. But the argument this afternoon was very different than many people in the courtroom expected. Originally, it seemed that that was the weakest part of the state's case, that really there wouldn't be much of a possibility that the Supreme Court would turn down this Medicaid expansion and rule it as coercive. But judging from the questions asked by the conservative justices, you really just don't know. They made many points that made it seem that they could consider this to be coercive, which would be a very serious blow to the Obama health care bill. It would mean that the main mechanism for getting more people health insurance would go away, and it would have vast ramifications. So that's really the way things are looking right now. I think at the end of this, most of the people who are in the courtroom realize that this is a case that the Supreme Court justices are looking at in a little different way than the experts had expected. Early on, experts had said chances are very, very good that the law would be upheld in its entirety. Now, if you talk to lawyers here who are in the courtroom or journalists who've covered the court for a very long time, they no longer think that's the case. Now, when will we find out? Probably late June, early July at the very latest. That's when these very important rulings will be coming down, and I will be here to cover that for sure. And tomorrow morning I'll have a very extensive story explaining all these arguments in some depth that took place in the court today. So I hope you'll read my story in tomorrow's paper. I hope you keep reading the Buffalo News, and thanks for watching.